afternoon, everyone. Welcome to the Justice webinar on the Windrush Compensation Scheme, What Happens Next. This webinar marks the 75th anniversary of the Empire Windrush, which arrived in Tilbury Docks in 1948. We would like to pay tribute to the invaluable contribution that West Indians have made to the country over the years, including personally my own grandfather who came from Guyana during that period. Today, we're going to discuss the Windrush Compensation Scheme, which was aimed at compensating people from the Windrush generation who had incorrectly and unjustly had their status taken away from them. Justice published a report in November 2021 reforming the Windrush Compensation Scheme. The report makes 27 recommendations on how to improve the operation of the scheme to ensure that it's accessible for claimants and to ensure that they receive the compensation they're entitled to. We found that there's a lack of independence, delays and inconsistencies in decision-making, awards that don't accurately reflect claimants' losses, and caseworkers who lack experience. The claim process is also very complex, and many claimants require legal assistance to complete their claim. However, there's no provision of free legal representation. We at Justice have been engaging with and urging the Home Office to implement these recommendations. Whilst there's been some small improvements to the scheme, there's still a long way to go. Today, we're going to hear from 4 experts on any ongoing barriers to the scheme and to improvements, as well from their experiences and what could be done further to improve the scheme. So the presentations today are going to be followed by a Q&A portion. So if anyone has a question, please put it into the Q&A box at the bottom of the screen. And then when we come to the end of the presentations, we'll deal with them then. So without further ado, I'm going to introduce our panelists in the order that they'll speak. So firstly, we've got Professor Martin Levermore, who was appointed as the independent person for the Windrush Compensation Scheme in March 2021. He's also the founder and CEO of Medical Devices Technology International Limited. Martin chairs the advisory board for HDR UK Black Internship Programme and the advisory board for Cancer Research UK. He's a senior associate with the Royal Society of Medicine, a chartered member of the Chartered Institute of Securities and Investment, and a fellow of the Royal Society of Arts. Martin also holds a visiting professorship in health, education, and life science at Birmingham City University. Justice convened a small advisory group to work with Martin on the recommendations in his first report as the independent person to the scheme. And Martin will talk to us about the findings of his recently published second report. Thereafter, we'll be joined by Ravi Nair, who will be joining shortly to the panel. Ravi's a partner at the international law firm BCLP, specializing in high-stakes commercial and group litigation. Ravi has significant experience in the design and implementation of innovative compensation schemes, including advising Manchester City Football Club on its redress scheme for survivors of historic child sexual abuse. Ravi will talk about his experience with other compensation schemes and, as a Justice Working Group member, some of the key improvements identified by the group. Thereafter, we'll be joined by Anna Steiner. Anna is the director of the University of Westminster Legal Advice Clinic, a senior lecturer and supervising solicitor and co-founder of the Windrush Justice Clinic, which is a partnership of community organizations, universities, and law centers that work collaboratively to help victims of the Windrush scandal receive the compensation they deserve. Anna was also a member of the Justice Working Group. And then last but not least, we'll hear from Glenda Caesar. Glenda's a Windrush claimant, a Windrush Lives member and campaigner. She was a member of the Justice Working Group and will talk about her experience as a claimant and current barriers that claimants are facing through the work she does assisting other claimants. And so with that, I'm delighted to hand over to Professor Levermore.
Good afternoon, and thank you for the introduction, Ira. I will apologize to all on this call if I fall off, but I've just seen a signal to say that my internet is slightly unstable. As Tyrone wonderfully stated at the beginning, I was appointed by the Home Office in March 2021 after going through a competitive interview to be the person who will be the independent advisor to the compensation scheme. My first report was really getting my head around what was already there, trying to listen to a large number of stakeholders to gauge and to evaluate different lived experiences, and also to ensure that information data was correct and correct in the way it should be. From that time, the Justice report that came out in August of 2021 made a number of recommendations, to which my second report was to elude and look at any improvements in the period from March 2021 up to the end of December 2022. As such, and it is widely publicized, the speed into which the compensation scheme has now moved is that applications are being concluded in a period of 6 months, down from 18 months. That's still a long way to go to make it more efficient, and work is being done in the background. My report, which came out in May, but actually looked at the period in December, show that the compensation scheme paid out was £54 million. That was up from £9 million when I took over looking at the scheme back in March 2021. I don't make any claim that that was due to any input of my own. I think that the increase in compensation and changes in policies was more down to the listening and airing and the implementation of stakeholders' opinions in terms of ensuring that if a claimant is proven to be entitled, that there is a nigh on immediate payment of a preliminary amount to that claimant. Subsequently, the element for me was also to test and to evaluate in my second report was, is there any objectivity around the Windrush Compensation Scheme's aims? What evidence was available both inside and outside, and how to consider any elements that were lagging and where more work needed to be done. I am informed, and I have seen that my second report was actually publicized on the government's website. So to that extent, the scheme is doing what it says. It is compensating. It is paying out. It is doing what it says in trying to reduce the length of time. And I know with the improvement and simplification of application form, it would appear that without external advice or support, claimants are going through. So just to round up or to finish my introduction, as we stand and the end of May 2023, there's been over £70 million offered or paid out. And in fact, the actual amount that has been paid out is over £62 million to 1,681 individuals, which represents 66% of the total number so far through the system. I will throw one more thing in before I conclude. Windrush, for the period of immigration, is not just a Caribbean issue. It's a Commonwealth issue and broader. And I'm ensured that going forward, the task and lens is to open up and look at the wider Commonwealth impact and try to look at how best to resolve any issues that a potential affected claimant endure. I'd like to hand back to you now, Tyrone, on that one.
Fantastic. Thank you very much, Martin. And so over, I think, to our next speaker, Ravi. Ravi, are you with us now and able to jump in with your remarks?
I think so. Let's hopefully it will go out and come back in.
Perfect. Well, we can hear you. We can hear you loud and clear, Ravi.
Brilliant. Excellent. Well, look, very glad to join you today, and thanks to you and to Maddie and the Justice team to resolving some technical problems at the beginning. I've been asked just to say a few words about the work we've done on analysing the compensation scheme and some of the changes we've made, as well as to talk about comparative schemes to some degree, which many on this call will know about. First and foremost, a real congratulations to the Windrush community to have celebrated so well this last week. And I say celebration because that's what this is as much as it is to talk about a compensation scheme. It's really celebrating a culture and a work ethic and intrepid explorers that came here 75 years ago yesterday. And we all know that there's a lot of pain involved here, and it's generational. It trickles down the generations. And my own view is that when this scheme was launched, it continued that pain rather than resolving it. And that really isn't the role of a compensation scheme, in my opinion. But others also saw that, and we came together at Justice and we published our report in 2021. Just to remind everyone, and I'm very grateful for Martin's comments earlier, but everyone will obviously have their own view on the launch of this scheme. On the 3rd of April 2019, the then Home Secretary stood up in Parliament and said that the scheme was a result of a meticulous approach in scheme design, and that they were confident of the proposals for the scheme, that they're closely aligned with what communities wanted to see, namely that the scheme was simple, accessible, and above all, fair. Now, those of us that have come together at Justice didn't have that view, and we wrote a report. Now, I'm in front of you today because of my experience that was said at the beginning on compensation schemes. Most of all, that I believe that as a tool done correctly, they should offer restorative justice and they should place people at ease and not further trouble them. My law firm, BCLP, like others, and there are a lot of really brilliant law firms in this field, have been spending at least 2 years helping survivors claim compensation. So we've got to see both ends, both a bit more of the academic perspective on how the scheme could be improved, but also how it's working at the coalface. And the other is that, as was mentioned at the outset, I've designed a number of these compensation schemes, advised on others as well, like Tesco, the Jimmy Savile scheme, and statutory schemes like the FSCS, and some of the industrial disease schemes. So there really is a body of schemes that the government could have relied upon, and that we certainly do rely upon in critiquing this compensation scheme. And as I say at the outset, this scheme really acted as a bit of an aggression when it was started against a community that was already browbeaten by the state. And in that sense, it felt a continuation of further institutional discrimination. And finally, I'm here today because two of us, Tim Bowden and myself, Tim at Deckerts, was asked by Martin to be able to support him in his independent work. So the consequences of the Justice report is what I'd like to spend a few moments talking about next. The first is, I want to make a comment, which is that constant and repeated change to a compensation scheme is not what I consider to be in the interest of justice. It is, however, all that we've been able to do. And as I'll outline in a minute, we think we've made some very significant changes with Martin's support and with others. And of course, ultimately with the Home Office's support. But it does raise a question about how we will treat those that have been through this scheme. And Martin quite correctly says that some 60 odd million has been spent in his last report. But if we change a scheme now midway through, will it still be just for those that have been through it? For those that have already been deemed ineligible, or if they've been deemed eligible, have been not to be entitled? And I use that analogy, that dichotomy rather, from Martin's most recent scheme. But it also aligns to another question. And I think that question is really not one for lawyers. It's not one for the brilliant NGOs, and it's not one for the brilliant charities that Anna, for example, represents. It's whether you continue to fix this scheme and to lobby for it to be fixed. And with our help, we're very happy to offer it, how we can offer practical solutions, or whether you scrap this scheme and start again. And it's obvious that in the things we're talking about today, we've seen no other option but to help and ameliorate what is a scheme that didn't start with the very best optimized way. So when the report was written, we had 3 recommendations that were taken on immediately. And those were relating to the independent person. And you've seen Martin, and he is a function of the success that we had and an outcome. And we're grateful for his support. Recommendation 6, that there would be video guides to help claimants understand the application process. And preliminary payments, recommendation 8, which is something that we had seen in the Lambeth scheme on sex abuse. But we do acknowledge that the hurt remains and that this scheme doesn't, to many, feel like justice. And just to give you a further example of that, I caught up with my colleague Alison Clarfield, who runs our pro bono team at BCLP. And as I mentioned, with the other law firms, it's taken them a significant amount of time to over 2 years of helping to get one person to receive an award. And that was when I last spoke to her on this subject in March or April of this year. So it's not simply that brilliant lawyers can even make this scheme work for those affected, because that's still taken a huge amount of time. And that isn't something that I consider consistent with good compensation scheme practice. Now, as we move forward, the question would be, where will the focus be? And again, we'll be working with Martin and the Home Office, if they continue to allow us to do so, to make the case for a couple of other changes. And I'd probably say there are 3 that we'll continue to focus on over the next 12 months. And obviously that's subject to what is said on in this meeting and other meetings like it that would have taken place this week, and we'll continue the conversation. The first is the provision of legal costs. Our own view, and my view in particular, is that really good compensation scheme practice, really good resolution of mass torts, doesn't leave it to those that have been hurt to have to find the money to make redress. It is a perpetuation of the injustice. And it hasn't really been done before. The community is simply left, however you define that community, is simply left to have to pay themselves. Now, we did talk about it in some detail in our report, and it's worth those interested looking that up, and we'll continue to work with the Home Office on it. But in my opinion, this is not a simple scheme, as the Home Secretary said it was when it launched. People are spending 30 to 40 hours per application. And that's a lot for an individual to do, bearing in mind that we're talking about an individual or their families that have suffered great harm over many years. So the fact is law firms are struggling, and that tells me there's something in the scheme that needs resolving. And simply put, we don't think it's fair. The Lambeth scheme had paid for legal costs, and they particularly changed those legal costs depending on whether someone was eligible and whether they were entitled. If they were eligible, they got a harm's way payment, but then they could also get more. The historical abuse scheme in Ireland borrowed something that I had drafted in the construction workers' compensation scheme. That is a different amount of money for legal costs depending on how big a hearing you've had, so that it's proportionate and good value for taxpayers, which is important. And obviously the Man City scheme that's been mentioned certainly engaged with law firms, built a panel together and actually paid for legal costs, but at a lower level where there were fixed tariffs. just to conclude, two more points that I think we'll focus on. It's whether there should be a fast track and a detailed assessment process. That means that applicants have a choice. They can elect fast justice, which can be rough justice, and can mean those that have been affected don't necessarily get what they might get in what we might call a detailed review procedure. But the option is there. And we know that this is a generation that is dying and being denied justice. So we want to continue to talk to the Home Office about how that can be done, legal comparisons where it has been done successfully, and see if we can get that going. Obviously, it will again ultimately be the responsibility of those who have suffered to actually say whether it's something they want. And so I raise it in this call so that everybody can engage. Thirdly, and finally, we're going to continue to push on making the scheme faster, better training, and thinking about appeals. And we'll be up there talking to the Home Office in the coming weeks, and we'll want to talk about some of that on your behalf. So that's what we've done. That's where we think it's going. We certainly feel confident in the precedents that have happened in the past and that there is good legal evidence for what we propose. And we think that there is a desire in our community of Windrush survivors for this. But the work goes on, and we look forward to working with you on it. Thank you.
Thanks so much, Ravi, for making all of those excellent points, and in particular contextualizing both of other schemes as well as the work that you and kind of Justice are doing to try and see improvements in the scheme, which I'm sure there'll be plenty of questions on later. And I would encourage participants to please do submit questions into the Q&A box as we progress through, and we'll try and get to as many of them as possible at the end of the session. So with that, over to you, Anna. You're on mute, Anna.
Hello, thank you for having me. So I'm not going to repeat the introductions. I'm involved with a number of other partners in assisting both through legal support, but also very importantly through both hand-holding support and through our community partners, Claudia Jones organisation, where clients want that support, therapeutic support as well. And clients who've had that additional form of support have expressed how important it has been to help them to navigate what is in itself a highly complex and can also feel to the claimant a hostile process as well. And I really wanted to highlight that. And the more time I've spent working with the partners, with claimants, with the legal side of things, looking at the policy side of things, it strikes me more and more, and I can't understand really why it wasn't thought about at the outset, that what is needed is a trauma-informed approach to addressing the injustice that has been inflicted on the victims and survivors of the Windrush scandal. I believe very firmly, after having worked in this area since, I think it's 2020 now, that the scheme needs to be removed from the Home Office. It's not righting the wrongs. And I personally am very much of the view that the only way that true reparation is going to happen for the huge injustice that has been inflicted on people by this country as a result of the increasingly hostile environment policies that led to the Windrush scandal is that it is removed, it's taken over by an independent body with an element of independent scrutiny. The government itself has access to the information that it is requiring claimants to provide themselves. The government has access to data held by the Passport Office, held by the Inland Revenue, as well as numerous other institutions. Hello? I was being investigated, for example, for benefit fraud, the government would find a way to access my bank account. They would find a way to access my employment records. Why are these instruments not being used in the way that the government has the ability to do so? They should be investing in these instruments to ensure that a properly administered compensation scheme is actually addressing the huge injustice that has taken place. And we are talking about a cohort of people who are not young. A number of people have already died whilst waiting for their compensation. When the scheme was formed or put into place, the government estimated that up to 50,000 people could have been affected by the Windrush scandal. The truth is, we really don't know. We don't know how many people in the UK have been affected. We don't know how many people are stranded overseas who've been affected. We don't know how many people have died on the streets or elsewhere having been affected. The government also estimated that the scheme would cost up to £260 million, that much in compensation is likely to be justified. And to date, we've heard that only 1,600 people have actually received an award. A total of, I believe, 70 million has been offered, which is far less than the original estimation. We know that only 5,600 people have actually applied to the scheme. At a bare minimum, we've had 17,000 people granted status under the scheme, suggesting that those people at least should automatically be entitled to compensation. The government has that information, having granted them status. Just to sort of go back to the key deficiencies, some of which have been highlighted. Overarchingly, in my view, the fact that the scheme is being administered within the Home Office is one of the, well, the major problem, or one of the major problems, together with the lack of legal aid. So the two key requirements, in my view, are that the scheme is administered by an independent body and legal aid is available for Windrush compensation claimants. And we did discuss in the Justice Working Groups that led to the Justice Report the possibility of having legal costs built into the scheme, which, yes, that would indeed help. We've heard that the huge burden that actually representing and assisting a claimant with making a claim has on a claimant, on a lawyer, sorry, let alone on a claimant. So somebody doing this themselves without the support of a lawyer really just find it quite problematic. I mean, everybody that I've spoken to, all the claimants that I've spoken to, have found it very difficult. And really, really importantly, it's important to understand that going through the process itself does, to a number of people, and most of the people I've spoken to, re-traumatize them, because they're having to relive the injustices, the impact on their life, everything that they've been through as a result of the injustice that has been inflicted on them. So what I suggest should happen is that the scheme is removed from the Home Office. An independent body, independent of the Home Office, administers it. Whether the scheme is rewritten or not, we've been told for some time now that would mean that things would take too long. But I heard something on Channel 4 where Martin said that improvements have been made over the last 18 months and we're getting somewhere, and we're getting there slowly, or words to that effect. But we don't have much time. It's no good saying that we're getting there slowly. Things have happened, things have been improved over the last 18 months. Justice needs to be delivered now, or as soon as possible, but done properly. And the choice of having fast justice that is rough justice, or things dragging on slowly, doesn't seem like a very fair choice, particularly given that even when it is slow justice, it's still rough justice. And I'm just going to give a couple of examples of, just to really highlight the difference that legal representation can make. And as Martin Ford said quite early on, that having legal representation does protect the claimant to some extent from reliving the trauma when going through the compensation scheme. And it's without doubt that there is a huge amount of trauma. We're looking at not just the trauma inflicted by the Windrush scandal, we're also looking at intergenerational trauma as a result of colonialism and the legacy of slavery on which this country has been built. So a couple of examples of how legal representation does make a difference. And these examples are in our report, the Windrush Justice Clinic's report into unmet need for legal support, legal advice in Windrush compensation claims. So we've had cases, for example, where an initial offer, very low offer has been made that has then doubled. One that springs to mind, initial offer of 40,000 increased to 70,000 for no apparent reason other than we just said the same thing again with some different words. There was no new evidence. I heard recently of a case where somebody was initially given a nil offer that was then subsequently increased to £280,000. Cases where, when we started the Windrush Justice Clinic, most of the claimants that came to us had actually listened to the Home Office and the government and submitted claims themselves without any legal representation. And then came to us because they'd been given, quite frankly, an insulting offer, an incredibly low offer. But as time progressed, we did also take cases that from the start and help claimants put them together and gather the evidence and put them together in a nicely indexed bundle with representations highlighting where the evidence is. And in a couple of those, some of those awards, first offers of 70,000 or over 100,000 were made. And to my mind, some of those cases were, if you're looking at the experience of the claimants, not as horrific as some of the others within our partnership that I'm aware of, where they've been offered half that. So there is a lack of consistency, and it does seem to be rather ad hoc. We did suggest, as part of the justice report and the working group, that a top-down approach be taken to decision making rather than the decisions being made at the bottom by caseworkers and then looked at by a senior caseworker before being sent off. But I don't believe those changes have happened. So what am I going to suggest? I'm not sure how much time I've got left. I think I was just going to say, give an anecdote, that in my naivety, I came to this work because I saw a gap. There was no legal aid, people were struggling to make these claims themselves, and I thought it was something that would be appropriate for a legal advice clinic. We could do something, students would be able to learn various aspects of legal practice under the supervision of qualified and experienced solicitors. And my background, my very first legal training was in asylum work, so I'm very used to dealing with the Home Office, and that has given me some insight as well. But in my naivety, when I started doing this work back in 2020, I read the form and it all sounded very friendly and helpful. I thought, oh, that's interesting. Not necessarily my former experience of dealing with the Home Office. And I actually believed and thought that the Home Office themselves would conduct the investigations as opposed to requiring the clients to repeatedly provide evidence. Often evidence that's already been provided is requested again and again. And just to say that a lot of this work is being done pro bono or on a conditional fee or damages-based agreement. And if it's not being done pro bono, then of course some of the legal fees will be paid from the client's compensation, which in my view, is fundamentally a flaw in the scheme, because the idea is to put people back into the position they would have been, but for the losses they've suffered. And clearly that doesn't happen in that situation. And then those of us who are doing it pro bono, we've heard Ravi saying, you know, a lawyer in his firm spent 2 years. It can take a lot of time. It's quite intense and quite hard work. And it does require the skill of a lawyer. So the other key points that I think remain flawed in the scheme are there remains an issue with pensions, loss of employment and loss of opportunity is not being properly addressed. If you're looking at projected losses, and you know, if you're looking at how losses are calculated in employment cases and in the employment tribunal or in personal injury cases, those factors are taken into account. And the government does have access to actuaries and specialists in this area who can work out things like this and project pension losses where people have been working for a number of years and not then lose their employment as a result of the Windrush scandal, and then don't get promoted and have the incremental rise in their salary together with incremental rises in their pension contributions and national insurance contributions. These things are not rocket science, I believe, for people who know about these things. So I'm just going to end with something that Dawn Butler said very recently, that anyone with a heart can see that the compensation scheme needs to be removed from the Home Office and given to an independent organisation that cares and has empathy. And I'll just repeat, a trauma-informed approach needs to be taken. Is that my time? I can see your face, Tyrone.
I'm popping up. That's your time. Perfectly done, Anna. Thank you so much for your contribution. And I just wanted to flag one of the comments that we received in the Q&A box from Glenn Parsons, who agrees 100% with all of the excellent points made by Anna. It should be definitely taken out of the hands of the Home Office. And Glenn also agrees with Ravi's comments that there should be a fast track process, making the powerful point that this needs to be put in place ASAP, as many of the victims of this injustice have sadly died. So I think that's a kind of important point of context for us all to bear in mind in terms of the urgency of the reforms that are needed. With that, I'd like to pass over now to Glenda for her 10-minute contribution, and then we'll turn to Q&A to wrap it up. Thank you so much, Glenda.
You're welcome. Hi, thank you for inviting me. I'm not going to go fully into my case as a victim because that is publicly known. But what I am going to discuss is my role now as a campaigner and as an advocate. And listening to the other panelists, there's quite a few points that they have raised. As a claimant myself and a victim that we personally had to go through, and what claimants are still going through. The claimants are finding that the wait is too long. That is number one in regards to the scheme. And like Ravi said, it's not an easy scheme. Sorry. Yeah, it's not an easy scheme. It's 44 pages long. It's not as when this first came out in 2019. I think it was under the then Home Secretary Sajid Javid, who when I asked him a question, I said, well, would I have to provide any more documentation on top of the documentation I did provide to prove to get my status regulated? And he said, well, no, it'll be on a first come, first serve basis. So, but it didn't go like that at all. What you found is that you had to produce more and more and more documents, and many people didn't have the paperwork. And obviously, like Anna has said, they have got this information. So it should be very straightforward. Once they know that you, the government understands that you have been affected by this, it's for them to do the looking up. They've got access to the HMRC, which is one of the things that we're challenging right now. One of the top points in the claim form we're challenging is about employment. What we're finding is that people, it's well known that if you didn't have your status back then because of that legislation, you couldn't get a job. And there were people who were taken out of jobs, or people who had taken a break out of a job and then weren't able to get back employment. But now when they put in a claim, it's, you know, you have to find us some information, whereas they've got it. They're not even being offered a general award anymore. It's like a nil award. So they're not even taking the time to look back or even say, okay, if this was your position, then perhaps we'll go on what you earned. Let's just say, okay, a tailor, a machinist, you go on what they would have been, or you use the general award, which I think is £1,147 a month. They're not even using that. So what's coming back, what I'm finding from people that I'm assisting, is that they're getting nil award on employment. There's also with the part in the form where it says about DWP, that needs to be taken out completely. And I think I mentioned it when I sat with Justice and said that, because it doesn't make any sense. The Department of Work and Pension are not prepared to even backdate sometimes of what they owe, and they will make some form of excuse. There's also the trauma part. There's nothing has been put in place for people who have been, this whole situation has traumatized a lot of people. Including myself, I know the trauma that I had to go through. And then it was more trauma having to speak to caseworkers who are not experienced in mental health or even experienced in dealing with a compensation scheme. But me personally, I still believe that it should be taken away from the Home Office, because I see it as if I would not negotiate with a thief if they had what belonged to me. So I wouldn't even talk to you. So I would have no trust in you. And I think that's what you're finding with the claimants. They have no trust in these civil servants, I have to call them, who has now been thrown into the deep end and having to deal with a compensation scheme. If the Home Office had taken this as the same way that they deal with when you're making an application for a passport, it may have been a little bit more different, because then it would have been a face-to-face and they could have actually seen the people who have been affected and have a clear understanding. With something that I discussed with the vulnerable persons team is that what you're finding in this cohort of people, some people are not as articulate and can't present themselves properly. So what happens if you come across a Caribbean person with a very strong accent and they talk in what we would call their patois, you know, then they go, how would you understand them? How would you be able to, it's very simple. They'll put on a form, well, me need my money, you know, how would you break that down? And that's what we're finding coming across. But legal aid and legal assistance is one of the major things that is needed on this scheme. And I know from that, because when I put in my claim, I came from administration within NHS, and I was used to helping people completing forms and doing everything else. But when I put in my form, simple, completed it, I thought it would have been straightforward, but it wasn't. And I did have to go and get legal assistance. And that's when I found with the legal assistance, they sat up and they listened. So it is needed. This shouldn't be even implemented into the awards. It should be a straightforward, we're going to pay for your legal assistance, and then you complete the form. Not implement it into the award that they're going to give you, because they'll find a way for them to do that, and then it's less award for the claimants. I don't know. I don't know what more to say. Because we've tried to make a lot of changes. The grassroots organizations, advocates, and other people here, we've tried to make a lot. There has been a lot of changes made to the scheme. Living costs for close family members, which was, a tiresome argument with them, because they didn't want to pay out to the close family members who had to support the primary claimant financially. They found that very difficult. It was just like one standard amount for close family, and it doesn't matter if you had to pay the bills or they didn't want to. But we had a battle with them, and now they've introduced the living cost into it. But there's still a lot to be done, and I think personally, take it away from the Home Office, give it to an organization who can deal with this. I heard Ravi say about the fast track, but would the fast track include earnings, loss of earnings, loss of pension? Would it include that? If it does, then perhaps yes. But what we're also finding is that the compensation scheme are now offering people £10,000. And what you have to remember is that it's a group of people who are dying and they are desperate because they've been in so much financial difficulties that they will take it. So we don't want to fast track. What we would like is for someone to take this over, look at it properly, detail it using actuaries like Anna says, and get justice for the people, because that's all we are asking for. And I have to say we, as someone who was affected, and that's what we really want. We just want justice. That's me finished, Tyrone. Thank you.
Thank you so much, Glenda, for putting all of your points so powerfully. And if I can summarize, I think your contribution in one word or a phrase, it's that lack of trust, I think, which plagues the system and makes it so important that that we achieve the changes that are needed. And thank you to all of the other panelists and to everyone joining us here today. I mean, it's clear from the tenor of the conversation, the questions, and all of your contributions that we could be here all day talking about this really, really important issue. And the conversation can continue. If anyone would like to follow Justice or any of the panelists and learn more about our work, please do get in touch. We're always happy to talk to people about these subjects and try and see change delivered. Thank you also just to acknowledge Tim Bowden and Marion Edge from Deckert for their ongoing support, and to Heidi Bancroft from Justice for leading on this work and Justice's kind of role in this. So thank you once again to all of the panelists, a kind of virtual round of applause coming from me, and I'm sure everyone will be doing that from home. And I hope everyone enjoys their day. Thank you very much.
Thank you, Tyrone.